Good morning. My name is Shazia Khan, and today's session we are doing is business law. And the session we're doing today is learning outcome 4, and then we have the final session, which is the assignment discussion session. So before we go into learning outcome 4, I just want to give you an overview of what we did in the last session, which was learning outcome 3. So in the last session, for learning outcome 3, we looked at elements of different nature of formation of a business. So we looked at the different formation of different types of business organizations. We looked at the nature and formation of a company. We looked at unincorporated and incorporated legal structures. We also looked at the different types of business like sole trader, partnership, and registered company. We looked at Companies House and what their role was in regards to starting a business. We looked at the meaning of what a company means. We also went on to look at the element of the legal structures. We also looked at incorporated legal structures. We went on then to look at the types of legal businesses. So like I mentioned, sole proprietorship, company, and partnership. We then went on to look at the element of limited liability partnerships and the classification of companies, and we looked at companies on basis of liabilities, companies on basis of members, and companies on the basis of control. We then went on to look at the digital role of Companies House or role of equivalent international organizations, and we looked at the elements of starting up a business. So what the procedure was when you start up a business and what you need to do. Like there were 7 factors that we looked at, which was business idea, assessing the situation, the business plan, researching your business, registering your business, sorting business finance out, and getting business advice. We then went on to look at the management of a company and looked at the directors, company directors and how they are appointed, and also looked at the element of the company secretary and how they are appointed. And we went on to look at auditors and the role of shareholders under Companies House. We then went on to look at company law informing business organizations, raising capital, and liquidation. We then went on to look at a history of the understanding of case law indicating the importance of common law and in regards to company law and business formation, and looked at the importance of company law today in regards to how Companies House deals with the information and how they have to look at the financial performance, and how it's so important that, you know, the element of creditors and customers and suppliers. So we looked at elements of that. So that was learning outcome 3. Now we're going on to learning outcome 4, which is to look at recommending what? Hi, Keith. Just 1 minute. Hi, Keith. Hi, Keith. You okay? Morning, Keith. Can you hear me? Keith, can you hear me?
Yes, I can hear you.
Excellent, thank you. So I just went through a little bit on what we did in learning outcome 3 just quickly, and we're starting on learning outcome 4 now. Can you see the slides?
Yes, I can see.
Excellent, thank you. So we're looking at learning outcome 4 today, which is looking at recommended appropriate legal solutions to resolve areas of dispute. And we'll be looking at legal solutions, so things like, you know, for employment law, we look at elements of health and safety, equality pay, severance pay, wrongful dismissal, commercial disputes, breach of contract, contesting a damage, looking at the element of commercial leases, why they're so important for an organisation, and looking at the disputes between directors and also contesting like damages claims and stuff as well. So we'll be looking at elements of that. So it's important to identify. When we look at areas of employment law, why do you think someone may dispute an area in employment law?
Sorry?
Why do you think, what kind of examples would be a dispute in employment law?
Deduction in salary.
The deduction in salary. What about if someone's being discriminated against?
Oh, yes, that can also be.
Yeah, that could be, it may be a woman, it may be a man, it may be because of your age, it depends. So key terminology, legal solutions for different types of disputes. So disputes can be a wide range of different contexts, things like individual disputes. So individuals against individuals would be things like, a civil dispute, and then business dispute could be commercial one. And dispute, the whole point of dispute is to find a resolution, and they call it alternative dispute resolution, ADR, and they use things like mediation, arbitration, and negotiation. What do you think mediation is? We're going to go through it a little bit more in detail, but what do you think mediation is?
I don't know.
So if you're mediating with someone, it's a third party, someone who's neutral, who's going to try to help you, come up and communicate with each other. If it's an employer and an employee, they're going to try to come up with a solution. So this person is normally an independent person that will come up with solution. It won't be anyone from the company or the organization. It will be someone independent. So areas of employment dispute resolution, and the first one we're looking at is health and safety. So health and safety is a really big issue within any work organization because, people, have accidents, and it's the duty of the business to make sure that everyone is looked after and protected, and they have a duty of care to that person. But that can always, go wrong sometimes as well. Not everyone, could someone might get hurt, something may go wrong, somebody may not follow the health and safety policies, and an accident may occur where, you're failing to, put in elements of, investigation. So they start to investigate and also, start to identify that, there are areas that may lead to criminal damage. So if someone's fallen or someone's hurt themselves or accident occurs, there are mechanisms in place to deal with that kind of issue because, not everyone follows policies, and procedures that put in place. So we've got the Health and Safety Act, which deals with employers making sure that they are safe and making sure the workplace is safe. And employers can report unsafe conditions. So it's up to the employer to report any unsafe conditions or refuse to work in dangerous conditions as well. It's up to them. While employers must establish that they follow the procedures and the protocols that they put in place to make the place safe. And some internal disputes for health and safety could be reporting unsafe conditions. So employers should report any sort of unsafe conditions. Why do you think it's so important to report things, Keith?
In order for it not to escalate further.
Yeah. So do you think having this risk assessment and making sure everything is safe and putting it in the a book, the health and safety book, helps follow the grievance procedures properly? If there's no grievance procedure in place, the individual can follow the grievance procedure, but make sure that everything is safe and responsible, and they conduct risk assessment. So making sure that the place is a safe working place. Also, what employers should do is offer training. Employees should be trained to make sure that they take care of themselves as well. And external dispute resolution can be if they report something to the authorities. If something is issues related to health and safety, they should report it to the government. It may be the authorities, it may be the government. If things fail, there's people, employees will seek legal action if something doesn't go according to. Do employers have a right to refuse a job if it's unsafe, Keith?
Yes, they have a right.
What did you say? Sorry, Keith.
I think they have a right.
Yes, they have a right, because they need to make sure that the workplace is safe, Keith. If it's not safe, they shouldn't have to do that job. So, for example, working in a factory that's not safe and there's liquids and stuff like that, they have that right to do that. So the next one is equality of pay. When we talk about equality of pay, concept is that everyone should be paid the same, being women, men, whatever it is, they should be paid the same for the same job. And an equality pay of claim is a dispute against employment that arises when an employee is paid less than a colleague of the opposite sex for the same work. So does that happen a lot, do you think?
Yeah.
Yeah, it does. It happens a lot where the employer, sometimes pays more, and this could be a grievance. In the article in BBC presenter, equal pay dispute have dominated the news in recent years. Since 2017, all UK companies with more than 250 employees are legally required to publish the gender pay gap. So, it's really, really important that, even if it's a man or a woman, they're doing the same job, they should be paid for the same job, not, discriminating against a woman or a man. And the key concept is that, if a woman works under the Equality Act, it's based on a comparator. They do the same work or similar work, and they should, obviously be paid for that work rather than being discriminated against. And the employer can defend the claim if they feel like, there's one person has more experience than the other. So it could be things like work rated as equivalent. It could be the same work, that they're undertaking the same work, or work of an equal, value. They should be taking that into account. And, dispute resolutions is where the employer would, raise a formal complaint with the employee and go through a grievance process, because they feel like, they've been not paid enough, but also, there's a grievance in place. And then it will go through the courts, and mediation would occur. And the reason is that it would occur because, they want to make sure that they are paid the same. And this equal pay is sometimes a complex issue, and solicitors are there to help individuals go through this. So it would go through a tribunal to make sure that everything is dealt with properly and that individuals are paid fairly. Key aspects is, like we mentioned, that it's work rated as equivalent, or it could be like work, that they do the same job. And obviously, Equality Act 2010 looks at including pay for equal work, and if they're doing the same work, they need to identify that they're doing the same work and be able to prove that. The next one is compromise and severance agreements. So settlement and severance agreements are legal contracts used to resolve employment disputes. And when an employer typically pays a sum of money to the employee in exchange for employee waiving their right to make future legal claims, so these agreements cover like final payments, the severance payments, and these are often cut to cover final payments. So it could be key areas here for compromise and severance could be areas, things like, termination of employment, dispute resolution, settlement of claims, negotiated terms. So these are things, and they can be used in redundancy if there's a discrimination or grievance case, or unfair and dismissal case, or gardening leave. So what is the difference between compromise agreement and settlement agreements? So there's no practical difference between compromise agreements and settlement agreements, but a settlement agreement is a legally binding contract used to end an employment relationship on mutually agreed terms, often in exchange for like a severance payment. And then the prior to 2013 July, they were known as compromise agreements. And a key change in the legislation, in the laws, was that discussions about settlement offers, the pre-termination and now protected unfair dismissal claims, meaning that they cannot be used as evidence. So they're not any difference. They're just the same thing. Wrongful dismissal claims. What do you think is a wrongful dismissal claim? What do you think that is? Give me an example of a wrongful. Sorry?
For example, if your employer decides to terminate your contract without any reasonable explanation.
Yeah. So it could be, where there's a breach of contract, while unfair dismissal is a statutory based on the fairness of the dismissal. So both can be claimed in an employment tribunal, but wrongful dismissal can be used in civil courts. Wrongful dismissal does not require a qualifying period of employment and focuses solely on whether the contract was breached, often involving issues like improper notice. Unfair dismissal typically requires at least 2 years of service and considers overall fairness of situation. So it looks at whether you've been wrongfully dismissed. It could be, that is something to do with the employer. It may be termination of a fixed term. It could be elements of, breach of contract. It could be statutory rights and employment law. So, it depends on the situation itself, but it could be a claim for a tribunal. So areas of employment dispute resolution. Wrongful dismissal is in breach of an employer's contract, a breach of a notice, and termination of a fixed term of specific notice. What's the difference between unfair dismissal and wrongful dismissal? So wrongful dismissal is, like we said, is a breach of an employment contract, such as giving lack of proper notice, while unfair dismissal is a breach of statutory rights, where an employer dismisses an employee for a reason or in a manner that is considered unfair. So the key difference from both of them is that wrongful dismissal is based on contract law and unfair dismissal is based on employment law and requires specific qualifying periods for the employer. So for wrongful dismissal, damages for financial losses incurred during the notice period, so where you've lost your wage or any sort of benefits. Whereas for unfair dismissal, compensation will include a basic and a compensatory award or potential reinstatement. So that's the difference for wrongful and unfair dismissal. Corporate and commercial disputes. So when we have corporate and commercial disputes are disagreements arising from business and company related activities. So it could be things like contract breaches, it could be shareholder conflicts and professional liability. And these disputes can be resolved through negotiation, mediation, litigation. And the whole goal of it is to achieve a legally binding outcome rather than going to court. So they have, types of disputes are things like, disagreements over contract terms. It could be shareholder and director disputes. It could be elements of debt recovery, professional negligence, where claims against professionals for errors in their work. It could be leasehold disputes, product liability, so, defective products and safety regulations. It could be competition litigation, and it could be banking and financial disputes as well. So breach of a contract. So commercial disputes occur when a disagreement, we've said, between both A breach of a contract is really where one party actually fails to fulfill their obligation, which is outlined in the legal agreement. It could be things like, if they fail to pay for delivery or goods or complete the work on time. And, you need to make sure that, when it comes to your, contract, it's very clear and binding, and, if you fail to perform the contract, you are breaching that contract. Or if you fail to meet any sort of deadlines for payments, or delivering any goods, you are breaching that contract. So it's really important that your contract is clear and legally binding for the individual to understand what's going on. How to resolve a contract. So there are mediation, two main ways to resolve that. And, the first one being mediation, which is a process where a third party comes in, a neutral third party. Now, this third party doesn't know anything about the situation or anything, and they help you facilitate discussions and between the parties to assist them in finding this common ground and coming to a settlement. The mediator does not make a binding decision. The parties retain control overall. So it's not as if they're making the last decision. They're just there to support them, and they are impartial as well. So there's someone from the outside that are impartial, and they will be the third party who are neutral, who will come to a resolution with both the parties involved and make sure, there's a resolution rather than going to a tribunal or the courts, because they want to resolve this. And mediation is normally quite speedy and has high success rates as well. Litigation, on the other hand, is the process of taking a dispute to court of law. And this is a formal, public, and often adversarial process where a judge or a jury hears evidence and arguments from both sides and issues a legally binding judgment. Litigation can be time-consuming and costly, and it's usually considered a last resort when other methods have failed. Courts really encourage individuals and parties to take the route of ADR, which is alternative dispute resolution, and mediation. Why do you think courts try to persuade parties to do mediation?
Sorry?
Why do you think courts kind of encourage parties to do mediation rather than go to court?
To save time.
Save time, save costing as well. It's very expensive. You may face quite high costs if you go through courts. So they try to stop that and encourage parties to go to mediation, and parties may, face less costs then as well. If you're actually going to court, it's quite a lot. The costs are quite a lot to pay for. So if you try to resolve that rather than going to court and mediate that and come to some resolution with both parties, then it's cheaper. So the courts try to encourage that. Do you think all parties are willing to mediate? Keith, do you think most parties are willing to mediate?
If they come to an agreement, then yeah.
Sometimes they do, sometimes they don't. Bigger companies will prefer mediation, but some parties don't. The next one is contesting a commercial dispute. And this involves a structured process beginning a thorough review of a contract and evidence, followed by attempts. So an alternative dispute resolution, escalating to litigation. So contesting, demonstrating that the claim losses were not caused by the actions, were not foreseeable, and it's a result of any breach or that other party failed to take reasonable steps. The initial steps for contesting a dispute resolution in commercial is, firstly, they review the contract. It's really important to gather any sort of evidence as well. And in dispute, seek legal advice. You know, it's not something you can do on your own. You know, you need to get legal advice to contest something. The next one is dispute between directors. Dispute between company directors often arise, you know, from strategic differences. Some directors maybe, you know, have differences and may not get on. So it may be things like control issues, financial agreements, or conflict of interest. Resolution typically involves internal mechanisms like open communication and negotiation, or external methods such as mediation, arbitration. And it's recommended to establish clear roles and responsibilities to promote transparency. You know, it's really, really important for the organizations to do that, you know, make sure they have elements of that in place. Causes of dispute resolution could be things like common causes. It may be disagreements over the company's direction. You know, it may be disagreements over the company's growth plans or investment strategies. It could be conflicts over profit as well, salaries, or the use of company funds. Again, it could be disputes from one director attempting to be a strong director, dominating everything. Situations where directors' personal interests may conflict with the company's best interest. You know, it could be things like that. It could be conflicts relating to changing of the board. So, you know, there are different causes of that maybe come in place. You know, it may be where one director wants to control everything, you know, or they've breached their duties. You know, it's really important to prevent this kind of things occurring with directors, that they establish a framework, a governance framework, where they, you know, implement things like clear rules and procedures for directors, you know, and define their roles and responsibilities. Because this, they need to kind of foster this culture of transparency, and, you know, make sure that they address disagreements together, rather than being at each other's throats, to be honest. So, you know, they try to come up with resolutions, try to deal with conflicts, but not, you know, some directors may want more power over the others, you know, and that sometimes happens in certain organizations. Why do you think that happens? Do you think directors sometimes have issues with power?
Yes, yes.
Do you think some people think that they're better than other people, and, you know, they want to, you know, disagree or take control over the organization? They're dominating.
Yes.
Yeah,
Yeah.
yeah. That does occur quite a lot, you know, where directors want to dominate the situation, you know, but under Companies Act, they have duties, directors, you know, that they must follow. They don't always follow them, you know, and they breach their duties. You know, so they make sure that, you know, it may be a simple breakdown of personal or business relationship between directors as well. That is another thing, you know, they may bring their personal relationships into it, you know, that could cause issues for the organization. It may be, you know, there may be allegations of negligence or misappropriation of assets. You know, they may have taken some money, or, you know, there's conflicts against where the director may be acting in their own interest. So it's really important that they act according to their duties. So we have commercial property. So commercial property refers to real estate used for business activities or to generate profits, such as offices. It could be retail stores, it could be factories, it could be restaurants. And this is different from residential property, which is used for housing. Income from commercial property is typically derived from rental income or capital gains. So what kind of types of commercial property can we have? What do you think commercial property that we can have?
Uh, Maybe mode of transport.
Yeah, yeah. Could it be restaurants? Could it be shops? It could be industrial units, warehouses. It could be
Yeah.
leisure, you know, leisure centers. it could be hotels, it could be cinemas and pubs. And, you know, these are the elements of commercial property, and, you know, they generate income. And commercial real estate is often a significant financial investment and can involve complexities, whereas residential properties are different. And, you know, for commercial properties, you need to make sure that, you know, there's rental incomes, you know, that is used for business purposes as well, not for residential purposes. Then we have commercial lease transactions. Commercial lease transaction refers to the entire process of leasing a property for business purposes, and this is an agreement between a landlord and a tenant who grants the tenant the right to use the property for commercial activities in exchange for regular rent. The process involves things like, firstly, negotiating. So the landlord and tenant discuss the agreement upon key terms such as rent, lease duration, maintenance, renewal, and then a lease agreement is drafted and signed by both parties, outlining the respective rights and obligations. And then the tenant then takes possession of the property and begins commercial operation. And the essential elements of a commercial lease include things like the parties that are involved, which the property itself, the lease term. You know, it's really important that you have a lease term in there, the rent and the fees, the use of provision. So you need to clarify what you're using it for, maintenance and repairs, renewal. So, you know, you need to make sure the lease agreement is made between you, the landlord, and the party. So real estate and investment. So real estate involves purchasing to generate returns primarily through rental income, capital appreciation, or both. It is a popular way to build wealth and diversify an investment portfolio, offering a tangible and relatively stable asset. So types of real estate investment is residential property, you know, where you have homes that you are single family homes and apartments, condos and townhouses. Also, another example is buy-to-let properties, where, you know, the main thing is buying the property and then renting it out, long-term rent, so you get a steady cash flow. HMOs. What are HMOs?
I have no idea.
What are HMOs?
I
Do you
don't
know
know.
that, Keith?
No, I don't know.
So HMOs are houses of multiple occupancy, and they're where someone buys a big house and rents it out to multiple occupants, generating a higher yield of profit. And this tend to be, you know, like a one-bed apartments or maybe rooms that they let out. Short-term rentals and holiday lets are for short-term periods for holiday makers, and these are investment properties where people will invest in these properties to gain some sort of profit out of that in the future. And also, you know, the key factors to consider when you are looking at real estate investment is things like your location. Why is your location so important when it comes to real estate property?
Uh,
Your location, you know, where you potentially, the rent, you look for areas with strong markets, you look for financial situation, you look at the time commitment, and risk assessment's really important. You know, you need to look at elements of that. Research, you need to research your market. It's so important you research your market if you want to go into invest in property and things like that. So have you got any questions, Keith?
I have questions.
Okay, so what we've looked at today in regards to learning outcome 4 is we've looked at elements of, you know, trying to look at areas of recommending legal solutions for to resolve areas of dispute. And we've looked at legal solutions for different types of dispute resolution. We've looked at these elements such as health and safety, we've looked at equality of pay, and we've looked at elements of dispute resolution, compromise and severance payments. We've also looked at elements of, the elements of wrongful and unfair dismissal and what that contains. We've looked at the difference between that. We've looked at corporate and commercial disputes. We've looked at elements of breach of a contract and what that involves. We've also looked at how to resolve a breach of a contract, and also two types of main ways to resolve disputes, which is litigation and mediation, which we looked at in detail. We also looked at elements of contesting a dispute in commercial law, and we looked at elements of dispute between directors of a company and causes of these disputes, why there's so many causes of that in regards to things like, the breach of duty. It may be that they are, more dominating partner. We looked at commercial property. We looked at the element of commercial lease transactions as well. And we looked finally at real estate and investment properties in regards to trying to invest in the property, what they are and what different types of, real estate and investment residential properties. So we looked at where you could invest in residential properties such as buy-to-lets, commercial properties, HMOs, and commercial properties, things like industrial property, where you can invest in land or mixed use property as well. Mixed use properties, things like, where there's a dwelling that has different uses. It could have, both residential and commercial uses, and we looked at elements of that. So to finish off, these are the references here. You can right click on these and go on to these references to help you. Additional reading is on Moodle for you. And if there's some reading there that you can do. Hisense, what's the best legal structure, incorporated or unincorporated. Any questions or any queries you've got, email learnerwork@ukvarsity.co.uk. Also, if there's any sort of issues around getting the recordings are all available on Moodle. So Learning Outcome 1, 2, 3 is available on Moodle. Today's Learning Outcome 4 will also be available on Moodle for you to have a look at in your own time. And then tomorrow's session, we will look at elements of the assignment discussion and all the learning outcomes together. So if you have any queries or any questions, please email learnerwork@ukvarsity.co.uk or ask me now. If you don't, thank you. Do you have any questions, Keith, before we finish the session? Thank you for attending today's session. Thank you for attending today's session.
No.
I'll see you tomorrow at 9 o'clock in the final session, which is assignment discussion. Thank you. Thanks a lot.
Bye.
Have a good day.
You too.
Thank you. Take care. Bye.